Okay, sige, thank you. So, if we're done with general provisions on partnership. We've discussed the basic principles that apply in partnership. Now we go to uh, the myth, one of the myth of partnership, which is the rights and obligations of partners. I don't know if we can finish this in one sitting, but I will try. Medyo mahaba, pero we'll try. Okay? Okay, when we're talking about rights and obligations of partners, there are subcategories. The first is the rights and obligations of partners among themselves. So, uh, parang ano yan eh. There is a right and obligation among partners, with the partnership, and with third persons. So, unahin natin yung the partners among themselves. So, Article 1784 states that a partnership begins from the moment of the execution of the contract unless it is otherwise stipulated. So you can find here a general rule and an exception. So the general rule, a partnership begins from the moment of the execution of the contract. The exception, if there is another stipulation. So ano yung execution of a contract? Yan na yung nag-contribute na sila. Okay? Yung actual contribution of the partners. Wait lang, may nag-message. Ay, may nag-join. Okay, so that execution of the contract is when the contract is put into play, meaning the partners who oblige themselves to give money, property, or industry actually give such promises. So yun yung execution ng contract. So una muna, pag nag-usap-usap sila, yes, the partnership can be perfected from the time that there is already a meeting of the minds. But the partnership only begins its life from the execution of the contract. Kaya makikita nyo dun sa example natin dun sa first topic natin na although there is already an agreement between partners, if they have not yet executed the contract or it came to a point wherein they wanted to execute the contract but the other one does not, okay, there are implications. Like this, for example, if the partnership agreed to be formed by the parties 1 year from the making thereof, the agreement must be in writing. This is based not on the partnership law but on statute of frauds. So, ang statute of frauds kasi, kapag yung agreement, basta ang agreement is, it involves more than 1 year from the meeting to its execution, kailangan in writing po yan. Very common yan kapag, actually, I think na-touch nyo ito sa obligations and contracts, pero hindi ko alam kung gaano ka-deep. But if yung agreement for the execution of a contract is more than 1 year or 1 year from the making of the contract, it should be in writing. Why? To protect you from frauds. Kaya ang tawag sa law na yan, statute of frauds. Kaya kapag, let's say for example, A, B, and C agreed to enter into a partnership, but they desire that the partnership shall begin or shall only be executed 1 year or 2 years from now. So, matagal yung 1 year. Baka magkalimutan kung 1 year, 2 years from now. So, ang ginagawa talaga dyan is sinusulat yan. Kaya po siya protected. Kaya po siya dapat in writing. Kapag hindi yan in writing, tapos nagkaroon ng aberya, dumaan sa korte, mahihirapan po kayo na mag-initiate ng kaso kasi alam nyo naman na 1 year or more than 1 year yung execution ng contract, hindi kayo in writing. Dapat in writing po yan. Okay, the law obliges the people na dapat yung mga agreement na ganyan, it must be all in writing. Okay? So, that's the first article. General rule, partnership begins from the execution of the contract, exception if there is other stipulation. Okay, execution meaning actual contribution of the promised money, property or industry. Okay, let's proceed to 1785. Okay, this contemplates partnership with a fixed duration or partnership formed for a particular undertaking na nag-transform into a partnership at will. Okay, so una muna, partnership for a fixed term or particular undertaking siya, and then it eventually transform into a partnership at will. How will it transform into a partnership at will? If the partnership is continued after the termination of the term, kung 5 years lang, tapos on the 5th year and 1 day or 1 week after ng 5th year, meron pa ring operations, tuloy-tuloy, it's considered as already as a partnership at will. Or, if for a particular undertaking siya, nung na-accomplish nyo na yung purpose or undertaking ng partnership, nagtuloy-tuloy pa rin yung business or yung partnership, without any express agreement, the rights and duties of the partners remain the same as they were at such termination, so far as is consistent with the partnership at will. Kaya tandaan nyo, nasa rights and obligations tayo. Although it became a partnership at will, the rights and duties of the partners remain the same as if walang nagbago. Ganun. Kasi alam natin, when a partnership for a fixed term or particular undertaking is naglapse na yan, yung fixed term or na-achieve or nagawa mo na yung particular undertaking, automatic madidissolve yan. Okay? Kapag kinontinue yung business after the term or after the undertaking, there is an implied agreement that you are continuing the partnership without any term or undertaking. Hence, it will become a partnership at will. Kapag partnership at will na po yan, gaya nga nung definition natin sa chapter 1 lesson natin, any partner can dissolve the partnership. Diba? Pwedeng bukas, makalawa, pwede nang ma-dissolve yan. Pwedeng malis yung partner kung gusto niya. Pwede siya mag-retire sa partnership kung gusto niya. Okay? The second paragraph of Article 1785, a continuation of the business by the partners or such of them as habitually acted therein during the term without any settlement or liquidation of the partnership affairs is prima facie evidence of a continuation of the partnership. Gaya ng sabi natin kanina, a mere continuation of the business by the partners or continuous acts that are habitually performed by the partners without any, hindi sila nag-undergo into winding up or liquidation, that is already a prima facie evidence of continuation of the partnership. Automatic din na na-convert or merong proof na yung partnership for fixed term or particular undertaking is dissolved na at meron ng at hindi na siya at magta-transform na siya into a partnership at will. Okay? Examples of this. Example of this, yung sinasabi natin continuation of business or habitual acts by the partners. Number 1, where the partners borrowed substantial amount of money to launch an enterprise and there was an understanding that the money would be repaid from the partnership profits. When this forms part of the ordinary transactions of the business. Okay? Borrowing money or financing their partnership. Where one partner loaned this co-partner money to invest in the partnership, with the understanding that the money would be repaid from partnership profits. Okay? So these are ordinary transactions during the existence of a partnership that continued kahit pa nag-expire yung term, kahit pa na-fulfill na yung undertaking, where the parties entered into a joint venture to build and operate a motel until it could be sold upon favorable and satisfactory terms. So kapag nag-end yung term or na-achieve nyo na yung particular undertaking nyo at merong mga ganitong transactions na nangyari, it is considered as a continuation of the business by the partners. Therefore, the partnership has deemed to continue its life. Okay? So, tandaan nyo po yan. The first obligation, to contribute capital. Okay? To contribute at the beginning of the partnership or at the stipulated time, the money, property, or industry which he may have promised to contribute. Simple as that, di ba? Of course, you promised to contribute. You should contribute. That is your obligation. To answer, what if the partner failed to contribute such money or property? The partner becomes a debtor of the partnership. So kung tatanungin kayo, give me an instance wherein a partner becomes a debtor of the partnership, ito yun. Okay? Because they promised to contribute money or property. Actually kasi, nag-execute kayo ng articles of partnership, ilalagay nyo dyan yung mga contributions nyo. So, merong basis para singilin kayo. Merong document. To answer for eviction in case the partnership is deprived of the determinate property contributed. Okay, sir, anong eviction? Pang sa PBB, na-evict ka. Di ba? Hindi. Apply natin. Okay? Let's say, for example, ABC. Mr. A promised to contribute stall. He convinced his partners B and C that certain stall was his, sa kanya daw yun. Okay? So, syempre, B and C, in a way of knowing, they believed, okay, on the time na mag-execute na sila ng partnership, mag-contribute or mag-i-stay na sila dun sa stall, they found out that the stall was not the property of A. Ngayon, imbes na mag-o-office sila dun, wala na silang office or napaalis sila. Yun yung eviction. Okay? When a person is evicted from the premises. Okay? And eviction only comes through a court order. So kapag na-evict yung partnership because hindi pala kay A yung property, okay, A will be liable. Sabi dyan, to answer for eviction. Either siguro, he or she is bound to give another commercial space for the partnership or can be valued. Kasi, bakit sir na in case of eviction, liable si A? Because of warranty. Okay? A, as a partner, warrants na nung sinabi niya sa kay B tsaka C na akin tong lupa. Di ba? He warrants na sa kanya yung lupa. So parang if you can imagine, parang there is fraud. Di ba? Kasi you promised that the property is yours, kaya mo nga kino-contribute kasi sa'yo. Therefore, there is warranty. Kapag may warranty, kapag na-evict yung mga mag-i-stay dyan, you will be liable. So, A will be liable. Okay? I hope you can follow. Next, to answer to the partnership for the fruits of the property, the contribution of which he delayed from the date they should have been contributed up to the time of the actual delivery. This refers to a contribution of partnership property lang. Property lang. Kung yung property na yun, earned fruits Let's say for example, apartment stall. Gusto nilang magpa-rent. That property earns rental income. The partner will be liable for such rental income if in case na there is delay in the contribution of his property as promised. So dito, unlike dun sa obligations and contracts natin na in order for delay to exist, there must be demand, di ba? Basic principle in obligations and contracts, no demand, no delay. Kung hindi ka nag-demand, walang delay. Dito naman sa partnership, demand is not necessary. Okay, demand is not necessary. Unlike obligations and contracts. And then the other laws, of course, if you are going to contribute a property, you have to take care of it. You have to exercise the diligence of a good father of a family pending delivery to partnership. Hindi naman porket, let's say for example, you promise to contribute a car to the partnership. Then nung i-contribute mo na, ay habang hinihintay mo yung date ng execution ng contract, okay? Hindi mo inaalagaan, ang dumi-dumi, nagagasgasan, nababangga. Okay? You are obliged to exercise diligence of a good father of a family. You have to take care of it. In short, take care of it. Bago mo i-contribute, dapat naman kahit papaano malinis, maayos, di ba? The last one, to indemnify partnership for any damage caused to it by the retention of the same or by the delay in its contribution. Precisely. Connect mo to dun sa kanina. Diba? Kaya dapat mong alagaan. May bibigay mo din sa iba. Alagaan mo. Diba? Ganun yun. Huwag mong sasaktan. Ganun yun. Okay? Kasi kung hindi, you have to indemnify for any damages you may have caused the partnership. If kinontribute mo yan, tatlo na lang yung sasakyan, tatlo na lang ang gulong, wala lang bintana, you have to pay, you have to indemnify. At least, ayusin mo naman, kompletuin mo naman yung gulong, gano'n. Okay? Yun siya in short terms. Okay? So that pertains to obligation to contribute property. Okay? The partnership, in this instance kasi, the partnership becomes the owner of the property contributed. Hence, such cannot be withdrawn or disposed of by the contributing partner without the approval or consent of the partnership or other partners. Take note, when you desire to contribute property to the partnership, you are saying that the partnership shall be the owner of the property. Therefore, kung later on, kapag hindi naging maganda yung partnership mo, gusto mo nang bawiin yung sasakyan mo, or yung lupa mo, or yung kung ano man yung kinontribute mo, hindi pwede. Because hindi na ikaw yung may-ari, yung partnership na. Okay? Pwede mong makuha yan if nag-consent lahat ng partners, lahat kayo. Sige, balik mo na yung sasakyan niya, okay lang. Okay lang. Pero hindi ikaw ang magde-decide. Lahat na kayo na partners. Yan ang ibig sabihin niya. Kaya, kung mag-enter kayo into partnership, think hard. Kung ano yung kaya niyong you can treat as a loss, you can contribute as property or as money. Okay? One basic thing about financial management, di ba? When you invest, you consider it as a loss. You don't invest your whole ipon or money, di ba? What happens when a partner fails to contribute property? Okay? Kaya sabi natin kanina, the partner becomes a debtor of the partnership. Other partners cannot rescind partnership contract by reason of default in contributions. The remedy instead would be specific performance with damages from the partner who defaults. Because, bakit specific performance with damages? Kasi yung promise mo is property. Pinramis mo na mag-contribute ka ng property. either lupa, building, kotse, pwede kang kasuhan, pwede kang singilin ng partnership. Whether ibigay mo mismo yung pinramis mo with damages, kasi nga na-delay ka with damages. Ang damages hindi sira o ano yan Kapag sinabi nating damages sa batas, okay, pera. Ibig sabihin, let's say for example, mag-contribute ako ng sasakyan, ang sinabi ko dun, brand new, pero dumating yung na-delay ako, kinasuhan niyo ako, specific performance with damages. Tapos hindi ko kaya magbigay ng bago. Okay? Pag nagbigay ako ng sasakyan with damages, ibig sabihin with pera. Kumbaga dun sa time na na-delay ka sa pagbigay ng property, i-convert yun into pera. Iba pa yung interest dun. Interest kasi pag money. Mamaya i-discuss natin. Pero pag yan kasi kapag property yan, damages. Ibig sabihin, imbes na sasakyan na lang contribute mo, mag-contribute ka pa ng sasakyan, tsaka pera sa partnership. O di sakit ng loob mo yun. Okay? So, tandaan nyo ang remedy kung failure to contribute property, specific performance with damages. In case of eviction, contribute another property. Kung meron. Kakaproblema ka dyan kung wala na siyang mahanap na stall or na commercial space. Or, kahit anong property. Let's say, for example, sasakyan. Kinontribute niya na yung sasakyan. Minamaneho na ng manager ng partnership. Then, isang araw, biglang hinila yung sasakyan. Yun pala, naka-loan, naka-utang. At yung partner na yun, hindi nakabayad sa utang. Di na-evict yung partnership. Nawala yung kinontribute na property. Bayaran mo. Bigyan mo ulit ng bagong property. Okay? In case of failure to perform services, although we're talking about property here, ilagay ko lang siguro, kung services naman, hindi mo pwedeng i-value ang service kasi. Kahit anong service pa yan. Kahit anong klaseng service yan hindi pwedeng i-value yan. Kasi, yung industry mo, yun na yung contribution mo Kung vinalue mo yung industry mo, let's say for example, ikaw yung inassign as managing partner to handle the affairs of the business. Kung vinalue mo yan, that is in effect a compensation. Diba? Diba? Which is, yun na nga yung contribution mo, tapos kikita ka pa. Di ba? Di doble na yun na benefit sa'yo. Why? You did not contribute capital. Ang kinontribute mo, industry. So, okay na sana yun. Kung sasahuran mo pa, di panalong-panalo na siya. Kasi sa kanya yung business, sumasahod pa siya galing sa business. Gets? Kaya hindi pwedeng i-value yung industry. Although, there can be stipulations granting or providing compensation to industrial or managing partners. Pwede yan. Ang sinasabi lang natin is kung ayaw niya nang mag-work or i-render yung service niya, you cannot value that. You cannot even compel him, di ba? Bakit? Involuntary servitude. Hindi mo pwedeng pilitin ng taong gawin ng isang bagay na labag sa kanyang kalooban, di ba? Obligation to do yan. Involuntary servitude, hindi pwede. Okay? So I hope you understand that. Okay? Valuing contributions. We're in obligations to contribute property. Okay? Property ito. So, kapag ang kinontribute is goods, you have to appraise that. Lalo na kung yung goods na yan is ibebenta din or supplies yan. Paano yung manner ng appraisal? Number one, the first rule in the manner prescribed in the contract of partnership, or kung ano yung pinag-agree nila, kung paano yung appraisal na agreed by the partnership. If wala, in the absence of stipulation, it shall be made by expert, but they shall be chosen by the partners, and it must be based on the current prices. So what the law aims here is fairness, di ba? You are to contribute goods. Of course, yung mga goods na yan, may selling price, o mayroong book value, meron ding yung fair value. It must be appraised para may record. Okay? In the manner prescribed, if silent, okay, if walang pinag-usapan, expert ang gagawa, but it must follow the current prices. So, the current market prices. That is with regards to goods contributed. Okay? I hope okay yan ha. Kapag goods, it must be appraised in the manner stipulated or prescribed in the contract. Kung silent, experts, current prices. Okay? Paano naman kung money? So, kanina, tapos na tayo sa property. Ngayon naman, kung money naman ang pinramis na i-contribute ni partner, ano ang gagawin natin? Okay? Kung sabi niya mag-contribute siya, let's say for example, September 30, you will give all your contributions to contribute on a date fixed, the amount he has undertaken to contribute to the partnership, and he has failed to give that contribution, let's say on September 30, yung agreement nyo, okay, he shall be liable. He shall be liable for what? Number one, yung principal amount. Let's say for example, A promised to give money in the sum of 50,000 pesos on September 30. Okay, if naglapse na yung September 30 at hindi nakapag-remit o bigay si A shall be liable for the principal amount, which is 50,000. Ano pa? For interest. Sa tandaan, yung sabi ko kanina, interest is different from damages. Oh, di ba? Sakit sa bulsa niyan. Bigay ka na nga ng principal, nabigay mo na nga, although na late ka lang, you are liable for interest. May legal interest tayong tinatawag. May rate yan. And damages. Okay? Depending on the damage caused to the partnership by virtue of your delay in contributing the promised contribution. Okay? Paano kung nakarely yung operation ng business dun sa 50,000 na yun? Kasi yung 50,000 na yun, pangbili pala ng supplies, di ba? O di, let's say for example, kahit siguro 5 days kang na-delay dun, bibilangin yun. Na kung 5 days sanang nag-operate, magkano sana yung income, walang income, yung babayad mo mas damages aside from interest. Di ba? You see? The next one, to reimburse any amount that he may have taken away from the partnership. This one we will discuss more later. Pero ito kasi, pag yung partner, siya ang may hawak sa money ng partnership. And he misapplied that money, nagamit niya yung pera na yun sa ibang bagay. Aside from the partnership use or partnership benefit. Let's say for example, ginamit niya magpampaayos ng brace niya, pampaganda, ganun. Or pang personal use. Kailangan niyang i-reimburse yun. Kailangan niya ibalik din yung pera na yun. Sino ba naman ang gustong mag-partner sa iyo kapag ganun? Diba? Yung pera ng partnership, gagamitin mo lang sa iba. Merong consequences yan. Okay? To pay for the agreed or legal interest if he fails to pay his contribution on time or in case he takes any amount from the common fund. As what I've said, di ba? Na-explain ko na pala, ito na pala yung explanation niya, di ba? Yun. You're liable for interest. You are also liable for damages. From the time fixed in the contract. Yung sabi mong September 30 to the time na magbabayad ka. Let's say, for example, yung 50,000 na yun, nabayaran niya lang ng December na. Oh. So, kakalculate nila yung interest. Kakalculate nila yung damages. So, baka mas malaki pa mamaya yung damages and interest dun sa principal na contribution niya. Okay? To indemnify the partnership for the, ito na yun, for the damages caused to it by delayed the contribution or conversion of any sum for his personal benefits. Ito na yun. Interest and damages. Ngayon, yung balik tayo dun sa partner na siya ang may hawak ng pera ng partnership na minisappropriate niya or ginamit niya sa personal use niya. May tawag dyan. Since you are trusted by the partnership to handle money, okay, you have that's part of your duty as the partner or managing partner. Okay, you can be liable for estafa. Oh, fraud, estafa. Okay? Ibig sabihin, ginamit mo talaga yun for personal use. In bad faith. Bad faith, fraud. Iba naman ang mere failure lang. Okay? Let's say, for example, partnership, si A, B, and C. Si C ang managing partner. Siya ang naghahawak din ng, the same time, siya na rin ang nagkikip ng money. Ng earnings nila for a day, siya ang nagkikip. Okay? Let's say, for example, on a Saturday, let's say hanggang Saturday ang operation ng business, and Saturday, at the end of the day, iuwi or itatago ni C yung pera, nasa kanya yung susi or what not, pwedeng iuwi niya din. And here comes Monday, C, hindi siya nakapag-report, di syempre, baka tinangay niya na yung pera. Pero, on the Tuesday, pumasok siya, binalik niya rin yung pera, hindi pala siya nakapasok ng Monday kasi may sakit, or nag-contact tracing, or what not, kung ano mang personal reasons. Mere failure is different from fraudulent misappropriation. Let's say, for example, ginamit niya yung pera, yun kasi yung example natin kanina, inuwi niya kasi kailangan niyang iuwi. Diba? Yung fraudulent naman yung act, ibig sabihin ginamit sa ibang bagay without the knowledge or without the intent to ever repaying it. Malay mo, sobrang pinagkakatiwalaan siya ng partners na hindi na nila chinecheck yung nare-remit or yung kinokollect niya na pera or yung mga earnings nila sa isang araw. Every day, kumukuha siya ng 1,000. Oh, di ba? Kung sa 30 days sa isang buwan niya yun, 30,000 din yun. Oh, yun ang pwedeng estafa. Okay? Because it's fraudulent from its very nature. It's fraudulent. It's wrong. Okay? Number 2, to maintain the trust and confidence given unto him by his partners. Okay, you can also relate that dun sa kanina, yung example natin kanina. Yung kapag entrusted ka to handle the money of the partnership, then we should at all instances observe utmost good faith, fairness, integrity in his dealing with the other partners. Diba? Therefore, each partner cannot directly or indirectly use partnership assets for his own benefit. Oh, let's say for example, may kinontribute sa partnership niya na delivery van or delivery truck. Pero instead na for delivery, ginagamit mo pang date for personal use or meron kang ibang business, doon mo ginagamit. No, hindi pwede. Kaya nga yung mutual trust and confidence and yung principle na the agent is the co-agent of the other partners. You are always acting for the partnership. Yan ang tandaan niyo sa partnership. Kahit siguro hindi nyo ma-recall specifically lahat ng articles or lahat ng concepts natin, basta isipin mo yun. Yung partner always acting for the partnership, for the benefit of a partnership. That's why, number 2, each partner cannot carry on a business of the partnership for his private advantage. Maalala niyo, example natin on the first lecture wherein engage sa real estate business and then merong potential customer na willing bumili at a higher price, imbes na sabihin sa partnership, sinarili mo na lang para naman yung commission or yung profit, hindi nyo napaghatian, sa'yo na lang, buong buo, di ba? Hindi pwede yun. That coincides with number 3, take any profit secretly, di ba? Kasi yung nabenta mo na lupa, just in case that lot was eventually sold, kahit pa hindi mo sinabi sa partnership yan, kapag nalaman yan ng partnership, they can always sue you and they can always recover that money. So you cannot hide that. Diba? Obtain for himself anything that he should have obtained for the partnership. Precisely. Diba? Business opportunities. Let's say for example, naghahanap kayo ng malilipatan na office or na maghahanap kayo ng lupa na ideal for the business. Merong nagtimbre sa'yo na merong murang lupa na center of na very feasible ang location, Okay, that is a business opportunity din. Hindi lang clients, hindi lang customers, yung mga ganung bagay, business opportunity din yan. Ngayon, anong ginawa mo? Since balak mo ring magtayo ng ibang business, hindi mo sinabi sa partnership, ikaw ang bumili. You can be made liable for that. Ngayon, ang tanong lang naman kasi dyan, kapag dating mo sa korte or pag nasa law school ka, how can you prove that? Which is, ibang tanong na dito sa pinag-uusapan natin because we're talking about theories and principles. Proving something kasi is different from this. Okay? Kailangan i-prove mo na siya talaga ang bumili. I-prove mo na mayroong business losses or potential business losses na nangyari sa partnership. Yun yung mga tinatakal ng law school. Okay? But for this, we focus on the theories. We're not gonna talk about evidences kasi iba naman na yan. Okay? Or proofs. Okay? Or each partner cannot carry on another business in competition with the partnership, of course. Gaya ng example natin kanina. Nakipag-partner ka pa kung magkikipag-compete ka rin sa partnership mo. Di ba? Kaya ang very purpose ng partnership is para magsama-sama kayo. Para lahat ng business opportunity nyo is i-disclose nyo sa isa't isa para kayong lahat guminawa kumbaga ang buhay. Ganun. He cannot avail himself of knowledge or information which may be properly regarded as the property of the partnership. Diba? Kung meron kang business opportunity, you cannot conceal that fact or that knowledge to your partners. If meron kang malaking client, you cannot conceal that to your partners. Kasi ang purpose nga ng partnership, kung babalikan mo lahat ng pinagsasabi ko noon, it's for the benefit of all, of everyone. Walang ikaw dyan, kumbaga sa relasyon or sa marriage, sa married life. Walang ikaw, kayo yan. Ganun sa partnership, kayo. Wala nang ikaw, wala nang ako. Kayo yan. Okay? Although I'm not married, pero okay. Ganun yun. We've talked about engaging in other business. There are rules that comes to play when we talk about engaging in other business. Okay? Rules in engaging in other business. The first one, if you are an industrial partner. Industrial partner, of course, you render service or work rather than money or property. You cannot, take note, you cannot engage in any A-N-Y business, any business. Ibig sabihin, kahit anong business, hindi ka pwedeng mag-engage kung industrial partner ka. Okay? Any yan, any business. General rule. Exception, unless expressly permitted by the partnership. So, general rule, industrial partner cannot engage in any business except if pinayagan ng partnership. Okay? Sir, paano kung walang hindi pinayagan ng partnership pero nag-engage pa rin si industrial partner in any business kahit hindi same business anong pwede mangyari sa kanya? Merong recourse ang capitalist partners. The capitalist partners can, number one, there are two options, dalawa. Hindi pwedeng dalawang i-avail. Pili ka sa dalawa. Number one, they can remove him from the partnership with damages. Biruin mo, matatanggal ka na nga sa partnership, magbabayad ka pa. Removal with damages. Anong second option? They can avail of the benefit you obtain from the other business with damages. Ulit po, with damages. So either matanggal ka at magbayad or lahat ng benefit or lahat ng profit na kinita mo dun sa isa mo pang business, mapupunta sa partnership plus bayad, damages. So, napaka-strict po ng rule with regards to industrial partners. Bakit sir, ang strict naman? Precisely kasi industrial partner, sila ang usually nagmamanage. Sila ang usually core ng business. Let's say for example, ikaw yung chef. Tapos mahati yung oras mo sa ibang bagay. 'Di ba? Hindi pwede yun. Ganun kaseloso ang partnership. Parang yung mga GF nyo, 'di ba? Parang yung mga syota nyo, di ba? Kailangan siya lang. Wala nang iba. Di ba? Any business cannot engage in any business. Kasi kung tumingin ka pa sa iba, baka i-break ka niya, removal and damages. Di ba? Ayaw mo naman yun. So, ganun yun. Okay? Kapag industrial partner, any business hindi pwede. Sir, paano kung nag-engage into any business? Removal, damages. Or, lahat ng profits, damages. Okay? An action for specific performance to compel the partner to perform the promised work or service is not an available remedy. Bakit? Because of the principle of involuntary servitude, which is your constitutional right. Although, wag ko nang pakomplikaduhin sa inyo. Basta involuntary servitude. Hindi pwede yan. Okay? Second rule in engaging in other business. Kanina industrial partner, ngayon naman capitalist partner. Any business din ba? No. They cannot engage in other business that are in the same line of business as the partnership. Kung real estate yung partnership, yung capitalist partners, they cannot join a partnership na on the same line na real estate din. Okay? Kung pharmaceutical company, hindi na sila pwede mag-join to another pharmaceutical company. Kasi nga, basically kinakalaban mo din yung partnership mo eh. Sino lang magre-rip dyan sa benefits na yan? Ikaw. Di ba? Paano naman yung partners mo dun sa isang partnership pati dun sa isa, di ba? Di ba? You think of that. Unless, may exception pa rin siya guys, unless otherwise stipulated. So kahit pa in the same line of business siya nag-invest kasi capitalist siya, remember capitalist, either money or property, kahit pa the same line of business siya nag-invest, pero meron namang kasulatan sa contract na pwede silang pumasok into the same line of business, pwede si capitalist. Pwede siya mag-invest. So general rule, bawal in the same line of business unless otherwise provided. Sir, paano kung nag-engage pa rin siya kahit bawal? Di ba? Ang daming kahit bawal ginagawa. Okay, ano ang pwedeng gawin? Ito naman ang pwedeng mangyari sa kanya. He may be required to contribute the profits he derived from other business into the common fund. Ibig sabihin, lahat ng profits na nakita niya dun sa other partnership, i-turn over niya rin sa partnership. Whereas paghahatian niya ng partners, pati siya. So yung whole na share niya sana, magpapaghatian nila. In case, let's say for example, si partnership A nag-engage, nag-form ng partnership. Ang partnership na finorm niya is ABC. Okay? Ngayon, nag-engage into real estate. Ngayon, nag-join na naman siya into another partnership, DEF. Okay? In the same line, real estate din. Ngayon, nag-loss itong ABC. Hindi pwedeng kukuha siya ng share niya dito kay DEF para ipasatisfy dun sa ABC. Hindi pwede. Kailangan siya lang ang mag-bear. Usual person will bear it. And also, he can be removed from the business. Itong mga nabasa nyo guys na removal, they call sometimes expel. So, hindi ka lang sa school na expel, pati sa partnership na expel ka. Okay? Okay, so, recap, industrial, any business hindi pwede unless stipulated. Capitalist, hindi pwede kung same line of business unless otherwise stipulated. Industrial, anong remedy mo? Removal with damages or profits with damages. Kung capitalist naman, contribute niya yung profits niya or he can be removed from the partnership. Okay. Obligations with respect to capital. Partners must contribute equally unless otherwise stipulated. Be careful with this. Baka kasi ang notion nyo, dapat ang contribution is equal. Hindi po. Okay? Although the general rule is that partners must contribute equally. Okay? Pero, lagi po yan na may unless. Di ba? Ilang beses yun ang nababasa. Except unless otherwise stipulated. Anong ibig sabihin ng otherwise stipulated, sir? Ibig sabihin, kapag may usapan sila na let's say for example, A, B, C, si A ang contribution niya is 90%, si B 5%, si C 5%, that is okay. Hindi kailangan na equal. Paano lang magiging equal? Maging equal lang yan kapag, wait lang I'm reading an email. Okay? Magiging equal lang yan kung wala kayong stipulation. Pero kung mayroon kayong agreement sa partnership contract nyo na kung ano man yung agreement nyo, yun ang masunod. Kung wala, equal. Ganun kasi yun. Baka kasi ang notion nyo, dapat equal. Hindi. Kung walang agreement, equal. Kung may agreement, yung agreement ang ifa-follow. How about in case of imminent loss of the business or the partnership? Partners must contribute additional capital to save the partnership, the venture. Take note, imminent loss. Kapag sinasabi nating imminent loss, ibig sabihin, the partnership is in danger na either mabankrupt or mag-close yung business. So there is a need, there is a necessity to save the business. Anong mangyayari kung may imminent loss, sir, at baka mag-closure or mabankrupt yung partnership? Anong dapat mangyari? Dapat yung partners mag-contribute ng additional capital. Sa ayaw o sa gusto, they must contribute capital. Okay? Sir, paano kung ayaw nung partner kahit na alam niya kapag hindi sila nag-generate ng fund dun sa capital magko-close yung business, ayaw pa rin nung partner. he shall be obliged to sell his interest to the other partner. For what pa, di ba? Alam mo na nga na kapag hindi kayo nag-contribute ng capital, yung venture nyo, yung partnership nyo is baka mag-close or baka mag-bankrupt, ayaw mo pa rin mag-contribute, ibenta mo na lang yung interest mo sa amin. Di ba? Hindi ka na namin kailangan. Ibenta mo na lang sa amin. Okay? Hindi ka na partner. Bakit? Kasi nga, balik tayo sa pinakauna na naman. For the common benefit of the partners or the partnership. Hindi mo na inisip yung partners mo eh. Hindi mo na inisip yung partnership mo eh. 'Di ba? Wala ka nang pakialam kahit magsara, 'di ba? Parang yung jowa mo pag nagloko, 'di ba? Ganun 'yun eh. Oh, wala nang pakialam. Deliberate refusal to contribute additional capital. Knowing na pag nag-contribute kayo ng capital, pwede pang ma-save yung business. Pero ayaw mo, wag na. Ibenta mo na lang sa amin yung interest mo. Kami na lang magtutuloy ng partnership. Ayun yun. Okay? Except of course, if industrial partner siya. Siyempre, industrial partner, ang kinontribute niya, service or work, alangan na sigilin mo siya. Although, siguro may pera siya, pero hindi siya kasali. Unless, voluntary. Okay? Pero hindi mo siya pwedeng singilin. Bakit? Kasi siya yung nagmamanage ng business or siya yung core ng business, siya ang gumagawa, siya ang nagtatrabaho sa business. Okay? Yun na yung contribution niya eh. Oh, ba't mo pa siya pipilitin na mag-contribute? Diba? Paano kung nagkanda-ugaga na siya kasi gusto niya ma-save yung business, diba? Oh. So, hindi kasali ang industrial partner. So, ganun. Kapag may imminent loss, in danger of closure of business, the partners must contribute. Or the capital partners must contribute additional capital. Bakit? Kasi magkuklose na for you to save the business. Kung may ayaw, he must sell his interest to the partners. Ito na yung point na siguro all this time meron tayong tinatawag na consent. Siyempre, interest ko yan. Dapat kung gusto kong ibenta, ibenta ko. Kung ayaw ko, hindi nyo ako pwedeng pilitin. Di ba? May ganun. Of course, there is. Pero when you put the life of the partnership on the line, it's much better na ibenta mo na lang sa partners yung interest mo. Kaysa nandyan ka, hindi ka naman nagko-contribute. Diba? O ibenta mo sa iba. Diba? Okay, so yun yung with respect to contribution of capital. The next rule, application of collections. Madami tayong keywords dito sa provision na to guys. First keyword, if a partner authorized to manage. Ibig sabihin yan, managing partner. Yan pa lang first phrase. If a partner authorized to manage. So, hindi basta-basta partner. Managing partner. Basta yung naka-authorize to manage. Okay? Collects a demandable sum which was owed to him in his own name. Ibig sabihin, si ABC, merong partnership ABC. Si X, may utang kay A. So, may demandable sum owed to A. From a person who owed the partnership another sum also demandable. Ngayon, itong si X naman, may utang kay A, may utang din siya kay ABC, kay partnership. Yun yung, I hope you can follow yung readings ko. The sum thus collected shall be applied to the two credits in proportion to their amounts. Ibig sabihin, kung ano man ang may bayad ni X or ang makolekta ni managing partner, let's say si A, dun sa utang ni X kay A or ni X dun sa partnership, dapat daw mahati in proportion to their amounts. Even though he may have given a receipt for his own credit only. Kahit pa gusto niyang i-apply para sa utang, para sa pautang niya kay X yun, hindi pwede. Okay? Ito, para mas madali. First rule mo nang tignan nyo, first rule tayo. Yung situation, yung ganun din, yung kanina, A, B, C partnership, A is the managing partner, si A, may pautang siya kay X, at the same time, si A, B, C may pautang din kay X. Ngayon, ang senaryo, si X, nagbayad siya kay A. Of course, dual personality kasi, sana magets nyo, dual personality ang ni A dito. One, A is acting for himself kasi may pautang siya kay X. Okay? And A is also the managing partner of ABC. Diba? So, is also acting for the benefit of ABC. So, ano ang mangyayari kung walang sinabi si X kung para kanino yung 2.5? Basta binigay niya lang kay A. Oh. Ang rule dyan, let's say for example, ang pautang ni A kay X is 2.5. Ang pautang ni ABC kay X is 2.5. Ang binayaran ni X kay A is 2.5. Gets nyo ha? I hope you can follow. Okay? So the total credit, ang sabi dito, the sum collected shall be applied to two credits in proportion to their amounts. So 2.5, yung pautang ni A kay X, 2.5 pautang ni ABC kay X, total of 5,000. So ang proportionality niyan is 2.5 divided by 5,000, 50%, 2.5 divided by 5,000, 50%. So, dun sa 2.5 na na-receive ni A, okay, i-apply niya daw, sabi sa batas, in proportion to their amounts. I-apply niya. So, since tig 50-50 yung proportion, coincidence lang to na naging 50-50, i-apply niya yung 2.5, 1 to 50 sa pautang niya at sa pautang ni ABC. Hindi niya kukunin yung buong 2.5. Okay? Ganun yung first rule. First rule yun kapag walang sinabi si X kung kanino yun. Diba? And yung scenario is ganun. Pareho siyang debtor ni A tsaka ni ABC. Ngayon, second rule naman tayo. Balik tayo sa law. But, should he have given it for the account of the partnership credit, the amount should be fully applied to the latter. Anong ibig sabihin nun, sir? Rule 2. Okay, same scenario. X pays A, wala siyang sinabi kung para sa utang ba ni A yun, ay para sa pautang ba ni A yun o para sa pautang ni ABC. Basta binayad niya kay A. Pag ginawa ni A na binigay niya yung buong 2.5 para sa partnership, pwede yun. Kasi favorable for the partnership. Okay? Favorable for the partnership. Yun ang sabi dito. Okay? The amount shall be fully applied to the latter, which is for the partners. Ang latter dito is partnership credit. Okay? Ibig sabihin, lahat yan mapupunta talaga sa partnership. Ibig sabihin, magandang partner si A. Maganda siyang managing partner kasi inuna niya yung interest ng partnership. Diba? Aside sa personal interest niya. Okay? Third rule. Okay? Na-take note nyo na yung kanina. This applies only to managing partner. Ngayon, merong law mamaya, may provision mamaya, article mamaya, na kung walang nakadesignate na partner, kung walang nakadesignate na managing partner, every partner is a managing partner. Okay? Kung walang nakadesignate. Let's proceed to Rule 3. Okay? Or paragraph 2 ng 1792. The provisions of this article are understood to be without prejudice to the right granted to the other debtor by Article 1252. But only if the personal credit of the partner should be more onerous to him. Onerous, sir, ano yan? Burdensome, di ba? Oh. Ang sabi sa 1252, sinabi dito, without prejudice to the right granted to the other debtor by Article 1252. Article 1252. He who has various debts of the same kind in favor of one and the same creditor may declare at the time of making the payment to which of them the same must be applied, unless the parties so stipulate, or when the application of payments made by the other party for whose benefit the term has been constituted, application shall not be made as to debts which are not yet due. In short, okay, si X na may utang kay A tsaka kay ABC, okay, si X na may utang kay A tsaka kay ABC, pwede siyang pumili kung kaninong utang niya i-apply yun. Yun yung 1252. Unless kung hindi pa due. Dun lang sa due, okay? So, si X, pwede siyang pumili kung ito, i-apply mo yung utang ko sa'yo. Or, ito, i-apply mo dun sa partnership nyo na ABC. Kasi may utang din ako dun, 2.5. Yun yung sinasabi ng 1252. Yun ba yung rule? Hindi po. Hindi po yun yung rule. Yun lang yung sinasabi ng 1252. Sir, bakit hindi yun yung rule? Meron namang referral sa article. Basahin niyo yung kasunod. But only if the personal credit of the partner should be more onerous or burdensome to him. Ibig sabihin, pwedeng mamili si X kung mas burdensome lang yung pautang ni A. Ganito, X pays 825. The obligation to A bears 20% interest per annum, while the obligation of X to ABC bears 5% per annum. Balik tayo dun sa onerous, burdensome. Kapag sinabi natin burdensome, may burden on the part of the creditor. Di ba? Ay, on the part of the debtor. Yung utang ni X kay A, meron siyang interest na 20% per annum. Yung utang ni X kay ABC, 5% lang. So, from that fact alone, makita nyo na yung utang ni X kay A is mas burdensome kasi 20%. Okay? Ngayon, kapag sinabi ni X na A, ibayad ko to sa utang ko sa'yo, okay, pwede. Kasi nga, mas burdensome yung utang niya. Okay? Gets nyo? Sana na-gets nyo? Pero kung baliktarin mo yan, kung mas burdensome yung kay ABC, dapat kay ABC yan. Okay? Pero kung sakaling sinabi ni X na kay A niya ibabayad yung 2.5 para sa personal na utang niya kay A, at mas burdensome yun, dapat mag-credit kay A yun. So, dalawang condition dun. Okay? Dapat pinili ni X na kay A i-apply at dapat more onerous. Okay? So, yun yung 3 rules regarding collection. Take note, ang nag-collect is managing partner. Okay? Kapag ang nag-collect is hindi managing partner, this rule does not apply. In short, ano man ang makollect ng partner na yun sa partnership, walang rule. Hindi ka authorized na mag-collect. So you are acting for the benefit of partnership yan. Itong 3 rules lang na to mag-apply kapag yung nagko-collect, the one collecting is a managing partner or authorized to manage. I hope that is clear. Okay? So, kung walang sinabi, proportionate application. So, kunin mo yung percentage. Okay? Pero kung kahit pa may sinabi, pero sinabi siguro ni A na i-apply ko na lang sa buong partnership, buo. Basta favorable sa partnership. Third rule, kung mas burdensome yung pautang ni A kay X, pwedeng i-apply yung buo kay A. Okay? I hope that's clear. You only have 10 minutes. A partner who has received in whole or in part his share of the partnership credit when the other partners have not collected theirs shall be obliged, if the debtor thereafter become insolvent, to bring to the partnership capital what he received, even though he may have given receipt for his share only. Paano ito, sir? Let's say, for example, the partnership of ABC itong partnership ABC na ito, merong pautang kay X in the amount of 4,500 pesos. Okay? Are you still with me? Okay. 4,500 pesos. Ngayon, si X, nagbayad siya kay A ng 1,500. Okay? So, kung tutusin, yung 1,500 na yan na yung share niya dun sa 4,500 na utang. Then, after that, maniningil na ulit yung partnership, wala na, insolvent na siya. So, in essence, ang nabayaran lang si A. Pwede ngayong subject ni B at ni C yung na-collect ni A, para mayroon din silang pag-atian. Okay? Para may put up, may lagay din sa capital. Bakit? Because you're acting for the interest of everyone, of every partner, di ba? Community of interest. Or for the benefit of every partner. Okay? Ang tandaan nyo lang dyan, may pautang yung partnership credit, nakabayad si X, pero ang nabayaran niya lang is yung share lang ng isang partner, tapos nag-eventually become insolvent. Okay? Yung nakolekta ng isang partner na yan will be subjected for the partnership. Di ba? Subject to bring to the partnership capital what he received. So, lahat ng na-receive niya, ilalagay niya sa partnership for the benefit of the partnership. Ganyan yan, guys. Lalo na pag may asawa na kayo. Ganyan. Diba? Yung kita mo sa misis mo. Yung kita ng misis mo sa misis mo lang. Mga ganun lang. Okay? Ayan ang isipin nyo, community of the interest of the partnership. Diba? Lagi naman, paulit-ulit naman. Lahat ng discussion natin kanina for the benefit of the partnership talaga. So, yun ang obligation ng each partners. Okay? For the partnership. I-try natin tapusin to. Kahit konti pa. Pero, 7 minutes. Pwede pa. Every partner is responsible to the partnership for damages suffered by it through his fault, and he cannot compensate them with the profits and benefits which he may have earned for the partnership by his industry. However, the courts may equitably lessen the responsibility through the partner's extraordinary efforts in other activities of the partnership. Unusual profits have been realized. So, balik tayo din sa unang phrase. Every partner is responsible to the partnership for damages suffered by it through his fault. Siyempre, if you are at fault, you pay for damages. Okay? Every partner yan, Walang sinabi na managing lang, walang sinabi na limited lang, walang sinabi na capitalist lang. Kahit sino, basta merong damage na nag-incur sa partnership. Let's say, for example, the partnership went into an investment venture. Okay? Yun pala, pyramid scamming. Di ba? Yun pala, pyramid scamming. Yung capital na sabi, pinangako sa kanila, 8,000 mo, magiging 25,000 or 50,000 or 100,000. Ngayon, biglang naglaho yung kumpanya, ngayon nawala. Yung ininvest ng partnership dun sa, magiging liable yung partner na nag-engage dun sa pyramid scam. Bakit? Through his fault. Ang pyramid scam, you earn by not doing anything. May ganun ba? You are financial management students or marketing students. You should know that basic principle regarding money. Hindi ka naman kikita through referrals lang, di ba? Which is basically pyramiding or pyramid scamming. Di ba? You cannot earn through referral. Naipasok mo si ganito, meron kang 2,500. Naipasok ni ganito, yung pinasok mo, merong 2,500. Hindi. It does not work like that. Okay? Every partner shall be liable. He cannot compensate them with the profits and benefits which he may have earned for the partnership by his industry. Hindi pwedeng, magtatrabaho ko na mabuti. Hindi. Unless, unless extraordinary efforts are exerted wherein unusual profits have been realized. Paano? Let's say for example, si ABC may pautang kay X. Ngayon si X, sabi nga natin kanina, gamitin natin yung example natin kanina, si X insolvent na. So, pagpunta natin sa basic accounting na I think na pag-aralan nyo din, kapag ang utang is hindi na mabayaran or insolvent na, anong ginagawa sa debt? Nira-write off ng mga CPAs, di ba? Galing. Nira-write off. Ibig sabihin, yung utang na yan ni X, hindi na natin masisingil yan. Kasi insolvent na siya. Okay? Paano kung yung partner na nagkasala, okay, dun sa partnership, bigla ngayon nakolekta niya. Out of the blue. Diba? Unusual profits have been realized nga, diba? Kapag di-write off mo na yan, hindi mo na i-expect na makikita mo pa yan. Loss mo na yan. Loss na yan talaga. Meron na yan sa balance. Meron na yan sa trial balance ng isang kumpanya na loss na yan. No hope for recovery. Diba? Ngayon, biglang nakolect ni A or nung partnership na at fault. Pwede yun. Pwedeng malesen. Ang sabi, they may equitably lessen his responsibility. Pwede. Okay? Tandaan nyo, lahat ng partner, pag may fault, liable to the partnership for the damages suffered at hindi niya pwedeng ibayad yung industry niya. Okay? Kasi kung ibabayad yung industry niya, babalik tayo dun sa discussion natin kanina, yung valuing yung services. So, parang compensation na yun, di ba? Which is not allowed. Okay? Pero pwedeng mabawasan yung damages na yan, yung utang niya sa partnership because of his fault through extraordinary efforts that allowed the partnership to have unusual profits. Gaya ng debt na na-write off na suddenly na-collect. Okay? Okay. Ito, mabilis lang. Who bears the risk of loss of things contributed? I think oblicon din, meron din ganito ng provision sa oblicon. Ang pinaka-importante lang dito, class, is that you have to determine who is the owner. Sino yung may-ari? Itong first, ang kinontribute lang is use. Specific and determinate things which are not fungible, where only the use is contributed. Yung paggamit lang yung kinontribute. Let's say, for example, building or car, hindi ko i-contribute yung car, pero pwede natin gamitin sa partnership. Yun ang gamitin nating service, yun ang gamitin nating office. Okay? Ang may-ari pa rin nun is yung partners. Therefore, the partner bears the risk. Anong risk? Risk of loss. In case mawala, masira, ma-destroy, the partner bears the risk. Okay? I hope that's clear. Ownership ang i-determine. Kung yung ownership na transfer sa partnership, specific, determinate, movable, immovable, real or personal property, partnership, kasi nga transfer to the partnership, medyo obvious to eh. So, bears the risk is partnership. Fungible things na kinontribute, of course, fungible or substitutable or consumable things. Kapag kinontribute mo na yan, of course, automatic matatransfer yan kasi ang fungible things are movable things. Okay, automatic partnership. Sila ang may-ari niyan. Therefore, they also bears the risk of loss. Kung supplies or things to be sold, kapag kinontribute na yan, siyempre ibebenta ng partnership, malamang ang may-ari niyan, partnership, malamang ang may bear ng loss na yan, partnership. Okay? Kung pina-inventory mo, things bought and appraised in the inventory, ano yung mga pinapa-inventory natin? Real property, di ba? Balikan mo yung Chapter 1 natin, if real property is contributed, PIS, public instrument, inventory, signed by all the parties. Kapag ina-inventory yan, at merong appraisal, merong value, partnership ang may-ari dyan. Kasi kinontribute mo nga. In-inventory nga ng partnership. Diba? Hindi inventory yan kung hindi naman partnership ang may-ari. Therefore, kapag nawala yan, nasunog, or nanakaw, the partnership will bear the risk. Okay? Pero with regards to inventories that are appraised, the claim shall be limited to the value appraised. Of course. Kaya nga in-appraise para ma-determine yung value. So, who bears the risk of loss? Determine the ownership. Kung sino yung may-ari, siya ang magbe-bear ng loss, ng risk of loss. Okay, so we extended by 1 minute. Let's continue with articles